We say that constitutions are self-explanatory. They don't need interpretation. They don't need analysis. They just need to be obeyed. And yet often we have court cases which lend complexity to what we would allege otherwise are straightforward and simple rules. One area in which there is a dispute that in my mind is not settled is the limits of municipal authority. It's a matter I looked into severally, perhaps most recently, the question of changing the ordinance to violate the Tennessee Constitution on marriage and the Chattanooga City Ordinance to have gay partner benefits. I pointed out when Collegedale first passed its gay ordinance benefit that it didn't have authority to do that. And after that analysis was posted on Nooganomics.com, the website of The Man Who Matters, the council rewrote it to account for what I had to say about it. And I'm very glad that David Fowler of the Family Action Coalition of Tennessee got the credit for that change, and that he deserves it. And so the question is, what are the limits of this authority? And the big question is, since we have a tide of police abuse across the country that is more and more evident and more stark since Ferguson in 2014 August, is policing constitutional, and do police departments have authority constitutionally to do what they do? Now, there's a conflict here in my mind between one perspective that argued by Basil Marceaux, who is a so-called a perennial candidate. He probably will be announcing for governor candidate sometime soon. Will you?
Yes.
Okay. And he's run for office several times as you might say, as a kind of protest candidate. That's how he's described in the press, as one to vote for if you were disenchanted with the way things are and you're grumbling and you've been abused by the system and have unsatisfied claims against the state that has apparently unsatisfied claims against you. So you're the one who's going to vote for Basil Marceaux. But he argues that there are two Supreme Court cases, both out of Chattanooga, that make a compelling argument, and that argument is the limitation on policing authority. And Basil, thanks for joining us. What is your argument in a nutshell? What are these two cases that we keep bringing up, and for which you say is great authority? What do they say? And then we'll discuss where this argument goes.
Okay, so we have two from the Tennessee Supreme Court. Tennessee versus Myers was in 1990. Then we have
that's Chattanooga versus Myers. City of Chattanooga versus Myers.
And then you have Chattanooga versus Kevin Davis. And Kevin Davis was a reckless driving case, state crime. And that was I went to Tennessee Civil Court of Appeals from criminal court, where they did a devastation of the city authority over citizens, and that with the police department, where they said cities are civil, cities can't go in other cities and take anything, sheriff can't come in, cities can't make a contract with the sheriff or the Sessions Court. Sessions Court is only civil because Congress never gave them the authority to have a jury.
You mean the General Assembly never did?
Right, never gave them authority to hold a jury trial. So everything the Sessions Court does is supposed to be a one jurisdictional mouth, and that's supposed to be penalty. On the other hand, all the city attorneys gave through their charters, gave cities a two jurisdictional mouth when they're only supposed to have one.
Well, listen, Basil, you're losing my listener on this discussion about the two mouths. Let's not get into that, because that's beyond what I think we can deal with. But and the points the listener needs to know that Basil, you've made these some of these initial points there repeatedly and voluminously in filings such as this one, which runs to probably 60 pages, in which you repeat these arguments with a certain kind of legal monotony. You keep saying these same things. Okay, now, but the question is, I guess the main question is the limits on the authority of municipal corporations. First of all, what is a municipal corporation? Where does it come from? Where do its powers come from? What is it?
It's a charter.
What do you mean?
Well, you can't have a city without a charter. You have to ask the state to become a city, and a lawyer creates the charter. and inside the charter it makes commissioners, and in our charters, they make police. And they cover everything with garbage and refuge pickup. Everything's designed that they think will come up is supposed to be in a charter. But when they make these charters in the old days, they allowed the judge to have two jurisdictions, one of civil and then one of punishment,
which is criminal.
And as we hope we get into later in the conversation, they can't do punishment.
Okay, let me ask you, Basil Marceaux, where is the block, the thing in the law that prevents cities from becoming punishing entities? That is to say, asserting their authority in a criminal matter for which there is punishment for the perpetrator. Where is that thing that blocks?
I think that blocks me. I think is the district attorney. You see, as long as he keeps accepting these false arrests and then punishing them without authority, which says in Davis he had no authority to. They have. Well, we get that. As long as he keeps taking these false arrests and prosecuting them, they'll just keep, because the judge listens to the DA. And as long as he listens to the DA, the citizen just stands there and found guilty. Don't matter if you have a lawyer or not. Oh, just the sentence is different. Does that make any sense?
Well, you're throwing things in my mind that if I respond to them, we'll never get to the main point. But the district attorney is a state agent. Police departments act as state agents, and we're questioning now the substantive underneath their authority. What is the authority for them to act criminally on every point of the statute, every point of the Tennessee Code of Annotated they can enforce? And you're saying, well, they don't have that authority. That's limited. And the question I asked you was, what is the blockage? What is the block of type in the law that prevents that from happening? My answer to that question is the $50 fine rule. What's your answer?
My answer is in Davis, they say take Davis and blow it up to 12 point, line 247 to 252. It has a historic background of Article 6, Section 14. This section unique to all of America's constitutional law. No other provision like this may be found either in federal constitution or.
What is that? Well, first of all, say what that article is. Is that the $50 fine rule?
This is what makes $50 rule. No court in Tennessee, not one court, all courts cannot charge more than $50. First offense $5. Second offense is $10. Third offense is $15, up to $25. When you get to 25, they're all $50 for the rest of your life. Now, and that's, but criminal, civil, it don't matter what court you go into today, they're all over $50. Tell me, I paid a couple of them, $800, $900, $1,500. So it's they use it.
What are you saying? The $50 fine rule. Here's what I understand, Basil Marceaux. Just tell me if I'm right. The $50 fine rule prevents municipal corporations, which are civil, from enforcing criminal statutes. They may have policing departments, but those departments are limited in their authority. They can't punish. Crimes, of course, have to be punished. Civil infractions are not punished. They are fined, and a fining is different. And the the penalty is controlled by the $50 fine rule that you're citing there in the Constitution.
Yeah.
Is that what you're citing?
Okay. Without a jury trial.
Right. These are fines. They're not jury matters. They're not criminal matters. They're civil matters. And Chattanooga versus Myers in 1990 explains in great detail the difference between a fine and a punishment. Right. A fine is restorative of the government's costs. It is a kind of a healing balm to a dispute between the citizen and the city. Right? So a fine is kind of a compensation, right? Like liquidated damages.
Dave,
right? Go ahead.
I don't know if that's correct.
Go ahead.
A fine is exactly what it says. It's a fine. It's not a cost because they said there is no cost. There is no appeal cost, and you have a right to a jury trial at no additional cost.
Well, we're talking about two different things here. I'm talking about the $50 fine rule.
I know, but the fine is exactly what it is. It's money. Money. It's it. Like money that they get for $50 for the more than $5 for the first. But cost is a different thing. You mentioned the word cost. It is not a cost. It's a fine. Okay. Yeah. So basically, it says here that this historic background of this thing. Only thing they know about it is it's a $50 cost, and you cannot be punished. Now, except for trial demurrable civil court has dual jurisdiction. So now my problem is I have argued in Judge Stillman's case called. I asked him about the Attorney General is overdoing his power against the citizen. He says the job is awesome. He says the job is he's immune from all crimes, whatever he does. But the thought of him overruling the Constitution is frightening. Now,
and you're thinking that that's what Judge Barry Steelman is doing in criminal court?
Well, I told him right there in front of him that when I stand in front of him, I am frightened. And I'm the best soldier in the nation. I don't get frightened easy. But I am, because one minute you're there, the next minute you're behind bars.
Okay, my listener's not following where our conversation is going, Basil Marceaux. Let's see if we can focus in. Where, and I answer my question again, that I haven't been satisfied with your answer, and that is, where is the limit to the punitive authority of city governments? And you're saying the $50 fine rule, which has these unknown origins. Is that what you're saying?
Right. They don't know where it came from. They just know it's there.
And that discussion is in Chattanooga versus Davis.
Yeah, and right. Myers.
And Myers. Okay.
And Alderman versus back in the 1856.
Well, let me ask you about this. It seems to me that the difference we have, Basil Marceaux, is that I don't quite follow your thinking. You're arguing these high court rulings that say that cities are civil. Is there a better way of doing that? And with that would be looking at the statute. For example, if you look at Title 16 of the Tennessee Code Annotated, where it discusses the jurisdiction of municipal courts, where many of these cases go. All criminal cases in Chattanooga go, if there's a citation involved, to sessions or city. And it says that municipal court possesses jurisdiction to enforce any municipal law or ordinance that mirrors or substantially duplicates or incorporates by cross-referencing the language of a state criminal statute. And here's the key word: if and only if the state criminal statute mirrored or duplicated or cross-referenced is a Class C misdemeanor, and for which the maximum penalty is $50. So in other words, the city can adopt statute as something it can enforce, but only if and only if there is a $50 fine limit and it's a misdemeanor. So that seems to be a more sturdy basis on the claim that you're making, that the cities don't have police authority.
Well, I make the claim that I can really know, and that is Chattanooga versus Jeremy Shinn. Jeremy Shinn on September the 2nd, 2015, he asked higher court from his drug case, pills and pot. That's one of the highest crimes you can get.
It's a criminal matter. It's a drug case. Jeremy Shinn is the defendant.
In criminal court, here my case from the city limits, they came back and said they had no jurisdiction over the matter. The city ordinance.
Tennessee Criminal Court of Appeals said it had no jurisdiction over a matter that arose from a criminal case prosecuted within the city limits.
Right.
How is that possible? That doesn't make any sense.
And they have no jurisdiction over a declaratory judgment, and they had no jurisdiction over one more jurisdiction. Yeah, they didn't have no jurisdiction whatsoever. And then now my personal case is there for insurance and registration and driver's license. They say that's a city ordinance. Civil must go to circuit court and then transfer mine to Tennessee Civil Court of Appeals, where they refuse to hear it because they can't hear a case from criminal court. Now, Jeremy Shinn, on the other hand, they sent his back to him and to this judge. Now, Then he went to court.
So what? All right, the question is, the listener's saying, so what? What does that matter? What are you saying?
So what? He went to the judge then, after he got that answer, and the judge threw that away and overruled the Tennessee criminal court and found Jeremy Sheridan guilty. $800 fine, 11 months in jail, suspended because he was dying of liver cancer. So here we have the higher court rules, and the judge don't listen to them. As long as the judges are immune forever to do whatever they want, we don't need a higher court. We just disband the higher court because they don't listen.
Okay, well, that's a dandy proposal, Basil Marceaux. But listen, what you really need to highlight here, I think, is that you have contradictory claims about jurisdiction. The criminal court says we don't have authority to hear an appeal from a criminal matter within the city jurisdiction. And the same case, let's clarify this. In the same case, have you sent an appeal to the civil court of appeals? And what did it say in the same case? Well,
they said they didn't have jurisdiction over.
Well, that means you're denied an appeal. How is that possible? Which court hears that appeal, civil or criminal?
Actually, I would have to go to circuit court first, and then Tennessee Civil Court appeal.
So, but these are criminal matters. Why would they go to circuit court? Well, they're criminal matters. They would need to go before Barry Steelman in the criminal court.
Well, this is okay. This is what I'm going to say. We're at a Tennessee Code, and you mentioned those. I'm at 278108. It says here, when it appears that they perfected a judgment from any judge of Sessions Court, it should be the duty of the clerk of Sessions Court, the papers, to hand this over to circuit court within 5 days. Which means as soon as I'm in circuit court. Now I got another one here.
We'll finish at the point. What's the point of why are you quoting that? What is the point?
Because if you go into Sessions Court and they find you guilty of murder, even though they not maybe find you, pass you on to grand jury, you can appeal the first 10 days of that appeal. Point of it is, you can appeal the circuit court, civil. Now, what does that make the county? That'll make the whole county civil, because every court. So, right at the moment, I'm using 275101. There it says, any judgment from any county court can be appealed to circuit court, trial de novo
trial de novo, which means a new case
within 10 days. So every case, I'm sitting there and.
So even criminal matters, you're saying on appeal for a trial de novo for a new trial are civil.
Yeah. So
civil criminal cases are turned into civil cases.
So I took my entire life of arrest and put them in circuit court just 2 weeks ago.
All right, what did you do now? Explain that right quick.
I took all my arrests, 30 arrests from over my life, and put it in the circuit court. I'm over in circuit court, and all the judges
post-conviction pleading
conspired, and they gave him all the Thomas because he's retiring.
Judge Neil Thomas.
And now we had a case in front of him that's going on appeal, and he didn't listen to any of it.
What is the point of all these recent reviewing of ancient cases that have dust on them and cobwebs on them, Basil Marceaux? Why are you reviving them under post-conviction pleadings?
What's the point? Under Jeremy Shin's ruling and my 27 ruling, I was in the wrong court back then. I was supposed to go to city court for civil only, but I got there in criminal. I was supposed to appeal that from there to circuit court. Instead, I went to criminal court through grand jury. So if cities are civil and they only have one mouth, there is no grand jury, and there is no criminal court for me to go into. I was supposed to write the circuit.
Well, okay. This is David Tulis, and we're talking with Basil Marceaux. What you're saying is not clear, okay? It is simply not clear.
One more time, then. We have a minute?
Go ahead.
All I'm saying is every judge in the 11th Judicial District is faulty.
Every judge is faulty. Okay,
right.
That's a
because higher court says they're supposed to have one jurisdictional mouth. They got two. And the one that's supposed to have the two jurisdictional mouth, the circuit court, trial de novo, only has one and refuses to make it. The mayor, the county attorney, they're all involved to keep the money of I call it racketeering, extortion, and jury fixing, and everyone overrules the Supreme Court.
This is David Tulis, and we're talking with Basil Marceaux. Now, you see why I have trouble understanding where Basil Marceaux is going. This is a very complex discussion, And I want you to know that David Tulis, your host here at Nooganomics.com and at Nooga Radio, I've given a great deal of time and attention to what this man, Basil Marceaux, who's been a criminal defendant many times. We'll hear in the next sentence a little bit more about some of his experience. He's been abused badly, and he wants standing, right? In a way, he accepts abuse because that gives him standing to make an argument about which we are trying to learn more about. This is David Tulis. I cover these topics at Nooganomics.com, the website for the man who matters, deep state stuff, even here in Tennessee. David Tulis with Basil Marceaux.
Traffic, news, and information. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM.